Hi, welcome back to I Now Pronounce You Divorce. This is Melone Hatley's podcast. For each week, we get together and we discuss things that our potential clients and our clients are going through. And we really try to take a deep dive into what we can do to help you through probably one of the most tumultuous times in your life. So today I'm joined by Mr. Erik McCauley, Rebecca Melone, and Dan Cuneo as always. Erik McCauley is one of the attorney managers here at Melone Hatley PC. So he gets to talk to all of our attorneys, gets to know the inside and outs of what's going on. And I wanted to give him an opportunity to introduce himself and let us know what he knows.
As Charles said, my name is Erik McCauley. I'm the managing attorney from Melone Hatley's Virginia offices. I am very excited to be here. We're going to be talking about some family law issues as they relate to the upcoming Thanksgiving and Christmas holidays.
Wonderful. Erik, thanks for being part of this. And I know everyone who's tuning in is probably thinking, okay, the holidays are coming up. They're so stressful. I need to make sure I have all my ducks in a row, but I don't really know what that means. And as we're kind of talking, I'm sure you're going to give us a lot of information but to kind of give us the starter here. What is your best tip for those who are entering into the holidays when they're reviewing their parenting plans?
Be proactive. For a lot of people who are going through divorce with custody issues or just separate custody issues and have never dealt with this in the holiday context before, you don't want to wait until the last minute. You want to coordinate with your spouse, the opposing party, make sure that you have a visitation schedule in place. You may not have a court order yet because you haven't been able to get to court. So trying to figure out, preferably months in advance, what the schedule is going to be. If the opposing side doesn't agree with what you want, you may have to go to court, and that's not something that you're going to necessarily be able to do on November 15th. You may have to file for an expedited hearing back in August in order to ensure that you get some kind of temporary Thanksgiving or Christmas visitation. So be proactive, think ahead, don't wait until the last minute. If you do already have a court order in place, then make sure still communicate with the other parents, make sure that you're both on the same page, that nobody's going to try to pull any last minute shenanigans. Having dealt with hundreds of custody cases, sometimes one of the parties will last minute, it's the last day of school prior to the Christmas break, and all of a sudden they're going to go visit their family up in New Hampshire, even though it's not their time to have the child, and it's too late to do anything about it. So be proactive, make sure that you're communicating with the other side and that you're both on the same page. That would be my number one tip.
So when you're talking about having this communication, what are the best methods that you've seen your clients use? Is it text? Is it email? Is it phone calls? Is it face-to-face? Like, what's the most efficient, effective way to have these conversations?
That is very much going to depend on the relationship between the parties. Obviously, you want to keep it amicable, but that depends on both parties working together, and not everybody's going to be able to do that. I understand that. I generally advise my clients to get everything in writing at least once. There are apps such as Our Family Wizard, which will track written communications when they were sent, when they were read by the opposing side, if a response was ever sent. So if you are worried about there being a violation of a court order or somebody running off with the children, having that evidence in an app like that, or even text messages, can be extremely helpful. Generally, if things are amicable, I would advise the parties to try to work it out either in person when they're doing a visitation exchange or over the phone, and then log it in writing somehow.
Putting it in writing, I think, is imperative. And when you're talking to clients, they put something in writing or they have a court order in place. And I had this happen with a client. They had everything worked out. We had been negotiating. We finally got an order put in place. The holidays came up. He was supposed to get the second half of the break. Mom calls and says, "Hey, I'm up at my family's house and wherever, and I'm not coming back. I'm just keeping him for the whole break." And she put it in writing. She didn't care. In reality, what can a client expect to be done in that situation?
So in that kind of situation, if there is time, you might be able to file for an emergency hearing. And courts, especially in Virginia, the juvenile and domestic relation courts, they like to also check out for the Christmas holiday as well, just as everybody else does. But they also are acutely aware that there are visitation issues that come up, especially around the Christmas holiday, and people try to take advantage of that. They're closed on Christmas Eve, Christmas Day, sometimes the day after Christmas, depending on where it falls during the week. If you have sufficient time, then you can go to your attorney or yourself, and you can go down to the clerk's office and you can file for an emergency hearing. You would have to spell out the basis for the emergency, and you would say, I just got these text messages, preferably print them out, maybe attach them as exhibits, saying that my ex-spouse is going to keep the kid or is going to take them out of state, something like that, in violation of the court order. We need to get an emergency hearing on this. We need to have this done now so I can get the kid for my Christmas visitation. If it's too late, and I have had clients who have called me on the evening of Christmas Eve or the morning of Christmas Day, and for clients out there, I understand you have last minute issues come up. You want to talk to your attorney, but your attorney is also trying to enjoy the Christmas holiday as well. So don't rely on your attorney actually picking up the phone if it's on Christmas Eve or Christmas Day when you're calling them. If stuff like that happens all the time, because sometimes visitation schedules will do the exchange on Christmas Eve evening or Christmas Day morning, you're not going to be able to do anything then. Unless it's an emergency situation where the child is at risk of being harmed, kidnapped, something like that, then you could potentially go to the magistrate for your city or county, and you can file for an emergency protective order. The police can show up at the other party's house. If there actually is some kind of credible harm of family abuse to the child or somebody in the family, that's pretty much the only thing that you're, practically speaking, going to be able to get done on the day of Christmas Eve or Christmas Day. If that doesn't apply, and it's not always going to apply, then your main remedy afterwards is going to be to file a contempt or enforcement action against the opposing party in court. And the court has various remedies available to them. They can fine the other side. They can modify the visitation schedule. If you've also filed a modified visitation, to give you additional time in the future. They can't necessarily make up that time that you lost. They can't give you that Christmas Day back, but maybe they'll modify the visitation schedule where the opposing party was supposed to have Christmas for the following year, and now you get it. Maybe you'll get it 2 years in a row. It's a court of equity. The court's supposed to do what is fair. So those are remedies that you might be able to get post Christmas holiday.
I'm thinking back when I would litigate a lot, and I have a two-pronged question. The first part is when you're speaking with clients and they now are separated and they're getting a divorce, and in the past they've kind of either split the holidays, or 1 year went to one side, the other year went to the other side, and now they're coming to you and saying, you know what, I don't want to do that anymore. I want to be able to have this holiday. And then the other part of the question that kind of ties into it is, how do courts handle that? Do they put a lot of emphasis on the history or the precedents, or is it kind of this is a whole new slate and we're going to have to litigate this?
So oftentimes courts will take into account, and litigators should also take into account, if there are family traditions, family meetings. The status quo is a powerful thing in family law. If you have a 15-year marriage and every Christmas during that marriage, the parties went to some family reunion out in Tennessee, and you have children, and those children have relationships with those cousins or siblings or aunts, uncles, family members, things like that, and that's been a benefit for them, the court is most likely going to want to maintain that. So if you have these family traditions that have been good for the children, that have been gone on for a long time, then you want to argue that. You want to bring it up that this is what we've always done. It's not been an issue. I would like to be able to have the kids during this time. And that could be a powerful argument for the judge. Judges, if there is something that is working, judges typically don't want to disrupt that. They want to stay with it. And to answer your first question, if you were in court, you would be getting an objection for a compound question, counselor. To answer your first question, if one of the parties, your client, comes to you and says, I don't want to do this anymore, you need to have a realistic discussion with them about their expectations and their demands. If they come to you and they say, I want Christmas every year, most times that's not going to happen. The judge, again, wants to do what is equitable for both sides. Christmas is, if not the major holiday, it's pretty close to it every year. I mean, Thanksgiving is a close second. You may have family traditions which emphasize other things, but at least in the United States, Christmas is the day. You get Christmas break for a couple weeks, all that kind of stuff. Everybody wants a piece of that time with their children. So if your client comes to you and says, I want to get them every year, then you need to evaluate the situation, see if there has been some kind of status quo where they have something going on where it might help your client's position on that. But most of the time it's going to be, no, you need to share the Christmas holiday with your partner.
You just reminded me of a client I had that absolutely did that. She said, I want Christmas. I don't care about anything else. I don't care about Easter, spring break, Thanksgiving. you can have the rest of them. I just want Christmas every single year. And it was a huge point of contention. And but for this demand about Christmas, everything else between these people was pretty easily resolved. It was like, we're just going to court to argue about Christmas. We've resolved all the other issues, all the other things, and we're just going and having a trial only about Christmas. You can do that, right? And ultimately, she did end up getting Christmas, but she did give up a lot of everything else. And for her, it was important. Everybody has their own priorities. Everybody has their own things that matter the most to them.
Mm-hmm.
What do you do when parties have like just separated, but someone's moved to another state? And now we're concerned. You brought up some concerns about going across state lines and maybe needing an emergency motion. But how do we try to amicably handle that if we know there has to be some sort of travel over state lines?
It's a good question. So first, if there's an attorney on the other side, try to work it out with the opposing counsel. If the parties are amicable, see if they can work out something ahead of time. It goes back to my first point about being proactive. Don't wait until December 23rd to try to work this all out. Now, traveling across state lines, here in Virginia, my office is about 30 minutes from the North Carolina border. So that's not too bad if somebody's just going right across the border to Moyock or Elizabeth City. They can work out a visitation schedule. Maybe one party drives one length of the trip and the other party drives them back, or they meet somewhere in the middle. It does become more of a problem if somebody's moving farther away. Here in the Hampton Roads area, we got a lot of military clients. If one of the parties gets orders to relocate to San Diego and the other party stays here with the children, that's going to be a little bit harder to work out, especially if the children are young. You can do some kind of exchange where one party will fly with the children to San Diego and they can spend some time there and they'll fly back. But you're going to also have to work out who's going to pay for the plane tickets, if there's going to be an accompaniment, if the children are very young, typically under the age of about 12 or 11. And if you can't get an agreement, most likely what's going to happen is that the court's going to say, well, the person who stayed and has the children gets to have the children for that Christmas break. They might be able to do something where if the other party can come back, spend some time where the children are located for the Christmas break or maybe in the Christmas holiday. But if it's while a divorce case or a custody case is pending, the court is more likely going to, again, try to keep the status quo where the children are until there can be some kind of final adjudication.
And state lines raises another problem. So I know down in our Hampton Roads area, a lot of courts are not willing to entertain parental kidnapping when we talk about somebody keeping the kids longer than what the order says. But we do have offices in Northern Virginia where the courts will still, our Northern Virginia office is basically on the other side of a river from Maryland, sitting in Fairfax County. The courts up there will entertain parental kidnapping, but you have to call the police, right? You have to call the police and say, my child's been kidnapped. It went over state lines, so it's not really good. We got some problems there. What do you advise clients on involving police in custody dispute matters?
The first thing that comes to mind is that police generally do not like to get involved in domestic disputes. Even if you have a court order, oftentimes the police will say, this is a civil matter. You need to go file something in court. There's nothing that we can do about it. If you want to get the police involved, generally speaking, now there can be exceptions to this. I've seen some very nice police officers who have stepped in when they didn't need to. But generally speaking, if you're going to get them involved, there needs to be some criminal element, some kind of element of danger or harm to one of the parties to increase the chances that the parties are going to get involved. Yeah, and regarding parental kidnapping, you're absolutely right, Charles. Some courts are more likely to entertain parental kidnapping than others. I had made arguments down here, and it's hit or miss depending on which judge you're in front of. And up in Northern Virginia, as you said, with them being right across from Maryland or DC, also relatively close to West Virginia and Pennsylvania, that can be a huge issue. If you are a parent who is contemplating just taking the child, especially in contravention of a court order, but even if there isn't one, and you don't tell the other side, and you don't tell the other side where the kid is going to be, you could be putting yourself at risk for criminal charges for parental kidnapping. And that might sound a little crazy. How can I be criminally charged for just simply taking my child to see his family in Philadelphia or something like that? But there are laws on the books, both federally and in Virginia, regarding that kind of behavior. So if you're contemplating that, probably not a great idea. Talk with your attorney, talk with the opposing parties, see if there's something that you can work out ahead of.
As we're talking about the travel and the distances between homes, in your experience, how do courts handle the cost? So the parties, by way of agreement or by court order, have, okay, you're going to this place for this amount of time. How do you handle the travel costs if there's airfare involved, and who picks up the kid? Are they allowed to fly alone? And is there gas money involved? Things like that, just in your experience.
In my experience, what the court looks at is who moved where and why. I have seen judges treat simply moving across the Chesapeake Bay up onto the peninsula like moving to another state, and others who treat it as going across 30 minutes across the border at Moyock is just a regular visitation kind of exchange. So the court would say, okay, did you move for work purposes? Did you remarry somebody who lives in another state or has a job somewhere and you moved there? Are you in the military? Did you get military orders so you didn't have a choice? That you had to get stationed in Minot, North Dakota because you chose to be in the Air Force and took that risk of being stationed in North Dakota? I've had some clients and friends who've gotten put up there as well. So the court's going to look at why you moved there. Was it for the benefit of the child? Was there abuse that was going on here in Virginia, so your client had to flee that to get away from that? That is absolutely a factor that the court looks for interstate custody and visitation cases. So there is almost a degree of responsibility and fault that the court will take into account when partitioning out costs for visitation exchanges. If you represent a client and she has been physically abused and has gotten a protective order against her husband, and on that basis, the only reason she's here is because her husband's in the Navy. She has no family or support structure here, and she wants to go back to South Carolina where her family is, and her parents have a relationship with her children, that sort of thing. That can be a very good reason for her to go to South Carolina. And then when we're talking about cost, the court would say, okay, husbands, the reason she had to leave was because of your actions. There's been a finding of family abuse. You're the one who's either going to be responsible for the driving of the children. You have to come down to Columbia, South Carolina, where we also have an office, and come back up to Virginia, or pay for the airplane tickets. So degrees of fault and reasons why are things that the court's going to look at.
How do you deal with the fact that the school calendar changes all the time? And right now we're lucky because we just got the Virginia Beach school calendar for the next 2 years. But last year it was like the end of July before they finalized, what the plan was going to be. How do you deal with that when you're trying to make plans between two different parties to share visitation over holidays and school breaks and things like that?
Mm-hmm. Yeah, that's a great question. And what I do in those situations is look at historically what that school district has done. So, and then compare that to the upcoming December, January, where the weekends fall, where Christmas falls, that sort of thing, and kind of predict based off that where I think the holiday schedules are going to be. If you have to go to court and you can't get specific dates yet, you don't know what those are, you could request the judge just split the Christmas holiday break in half and just do a 50-50 split wherever those days may be. There are some people that prefer to do the visitation exchange on either Christmas Eve or Christmas Day morning, so that wouldn't matter as much. But I usually try to compare what the school district has done in the past and match that up to what the upcoming weekends and Christmas holiday are, and then adjust accordingly once the schedule actually finally comes out, as you said, maybe late July or early August sometimes.
Yeah, when you have kids in school, it's always tough, right? I know everybody likes to talk about family law not being a zero-sum game. I'm always like, hey, time with your kids is zero-sum, right? You're not getting it back. You can't split time once you're separated. Rebecca and I were talking about this morning, right? You're in a relationship and you all of a sudden you go to seeing your children 365 days a year to maybe now you're seeing your kids 60 days a year. And these holidays become direly important in those senses, and maybe even more important than they were while you were together as a family, because now you're really looking at that. So, I want to thank you, Eric, for taking time to talk to us today. When you come back and join us for part 2, I really want to kind of shift this conversation because as we go on the holidays, we think about the time that we're going to spend with our children, we think about the time that we're going to spend with our family, but we also need to think about the end of our own time, right? Our testamentary gifts that we would have, and looking at that as being an opportunity to come together as a family. And now that you're separated from your spouse, thinking about somebody who would have power of attorney over you, thinking about somebody who had power of attorney in case something happened to you to grab your kids from school if your other spouse was at work. And all these little things that sometimes we take for granted while we're married. So I thank you for everybody listening. Please like and subscribe and join us next week for part 2, where Eric's going to tell us everything we need to know about testamentary gifts during the holidays.
Thank you for joining us this week on I Now Pronounce You Divorced. Please join us next week for part 2.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.